Hello and welcome back. Checking my sound, make sure I'm not on mute here, Jamie. I was having a few problems on my end, but they seem to be worked out. Welcome back, everybody. My name is Gavin. This is my channel. On this channel, we like to cut through all the fluff and sensationalism of true crime and get into the nitty-gritty of cases. And we have covered, I think this is probably, if I counted correctly, this is the 58th or 59th video live stream that we have done on the Madeline Soto case. And Madeline, to bring you up to speed, was a 13-year-old girl in Kissimmee, Florida. Madeline lived with her mother, Jennifer. Also, two other roommates lived in the house. Actually, three other roommates lived in the house, one of which was her mother's on-again, off-again boyfriend, a man named Stephan Sterns. On February 26th of this year, Madeline was reportedly, by Mr. Sterns, dropped off at school on that morning, February 26th. And then later that day, when Jennifer Soto went to pick her up, she was nowhere to be found. There was a missing persons case opened. Of course, I'm just skipping over a whole bunch of stuff. But what it turns out to be is that Madeline was never taken to school. Instead, police say this man killed her and threw her body into a field near a row of bamboo. And the worst part, I think, oof. How could it get worse than murdering her? No, it gets worse. For 5 years, police say he was essaying her and he was making recordings of it, video and photographic recordings of it. Now, Mr. Sterns is facing two different cases, one of which has to do with the essay. Let's get his face off here. And the other has to do with the murder. And just a couple of days ago, you guys have been asking me what's going to happen on this case. When is this going to get to trial? And I've been telling you, it's going to be a while. It's going to be a while. I know that they have the case. They have things on the calendar, a jury trial on the calendar, but it's not, my experience tells me that's not going to happen that quickly. We're going to see some motions first, okay? And lo and behold, filed yesterday, day before yesterday, a motion. This in the case of the state of Florida against Stephan Sterns. Let's go ahead and read this. Now, I have to look this up, which case this is. I believe this is the, it actually doesn't matter which case it is, okay? This is a motion that was filed by his attorneys. If we go down here, Robert, he's being represented by the public defender's office there in the, oh my goodness, why am I blanking right now? What is this? This is Osceola County. So he has public defenders. Now, hey, there are fine attorneys that work in public defenders' offices all around the nation. Fine attorneys, good, solid attorneys. So I'm not putting casting any shade on the public defender's office. I'm just simply saying that in the beginning, it looked like he had an attorney that he hired, but apparently he was able to show indigence, and so the public defender's office is going to be defending him. Now, what is this motion about? This motion is asking the court to modify jury instructions regarding the burden of proof. And let's get into it. This is one of those things, guys, kind of caught me out of nowhere because honestly, but okay, let's read it. Comes now the defendant, Stephan Sterns. Let me get some water here. Oh my goodness, I have a drinking problem. Everybody. Have I told you how happy I am with my water drop reverse osmosis system? Most amazing thing. Anyway, okay. Comes now the defendant, Stephan Sterns, buying through his undersigned attorneys and files this motion to modify jury instructions regarding the defendant's burden of proof. In support of this motion, Mr. Sterns would state as follows. By the way, I'm sure there are new folks among us today. Thank you very much for joining me. I call the live chat the fishbowl. I can't remember who suggested it, but that's what I didn't come up with it. That's what we call it. If you put GF in your chat, I will see it. We're going to go through some of your comments, okay? All right. The standard jury instruction 7.11 reads in pertinent part, so not in full, but this is the part that is apropos. It is the defendant's burden to prove that one or more mitigating circumstances exist. Mitigating circumstances and need not be proven beyond a reasonable doubt. Mitigating circumstances and need not... That is weird. I think that "and" is superfluous. Mitigating circumstances need not be proven beyond a reasonable doubt. Instead, the defendant need only prove a mitigating circumstance by the greater weight of the evidence, which means evidence that is more likely than not tends to establish the existence of a mitigating circumstance. If you determine by the greater weight of the evidence that a mitigating circumstance exists, you must consider it proven and give that evidence such weight as you determine it should receive. You need not reach a unanimous decision about whether the defendant has proven the existence of a mitigating circumstance. Any juror persuaded as to the existence of a mitigating circumstance may consider it in this case. Now that begs the question, what's a mitigating circumstance? Let's ask Uncle Google. All right. A mitigating circumstance is a factor event that reduces the blame or responsibility a person has for a criminal offense. Mitigating circumstances can be used to argue for a more lenient sentence during the sentencing hearing, which begs the question. I mean, we're talking about mitigating circumstances. We haven't even really gotten into this motion, just that this is what the standard jury instruction says about mitigating circumstances. But this begs the question, what mitigating circumstance is he going to claim exists in order for to reduce the blame or the responsibility for the crimes that he has allegedly committed? Okay, I say allegedly. I think he committed them. All right, so getting back over here. All right. And by the way, guys, I mean, I think you guys all know this, but in each jurisdiction throughout the United States, usually on a state level, because when you get into felony courts, they're typically, they will be not district courts, but I think they are technically district courts. I know in the Commonwealth of Pennsylvania, they don't call them that, but they're basically the state cut up into little jurisdictions, right? But they are state courts. So it depends on each state. They each have a standard jury instruction. And we saw this in the Karen Reed trial, that they wanted the jury instructions changed because this isn't right and blah, blah, blah. That's what's happening in this case. Stephan Sterns, through his attorney, is saying, wait a minute, it should not be my burden. Actually, I'm getting ahead of myself. Let's get in here. Okay. Section 921, verse 141, Florida statutes, does not impose a burden of proof on the defendant to prove mitigating circumstances. Rather, it states that in cases where the court imposes a death sentence, the court shall enter a written order addressing the aggravating factors and the quote, the mitigating circumstances reasonably established by the evidence. End of quote. Mr. Stern requests that any language that places a burden on the defense of proving mitigating circumstances be removed from the instructions to the jury. Hang on just one second. Does it use the word prove? It does. The burden to prove. I think they do it. Okay, let's just keep on going. Florida's capital sentencing scheme begins with a determination of whether a defendant is eligible for the death penalty. which requires a unanimous finding that a statutory aggravating factor has been proved beyond a reasonable doubt. Next, the jury must consider whether sufficient aggravating factors exist and, quote, whether aggravating factors exist which outweigh the mitigating circumstances found to exist, close quote. That bold was added. The Supreme Court has expressed doubt whether it is even possible to apply a standard of proof to the mitigating factor determination. And it says, the court explained, the facts justifying death set forth in the Kansas statute either did or did not exist, and one can require the finding that they did exist to be made beyond a reasonable doubt. Whether mitigation exists, however, is largely a judgment call or perhaps a value call. What one juror might consider mitigating, another might not. And of course, the ultimate question, whether mitigating circumstances outweigh aggravating circumstances, is mostly a question of mercy, the quality of which, as we know, is not strained. So I'm going to keep going on this, but maybe this instruction is written poorly. Basically, what he's saying is, no, mitigating circumstances can be found to exist. We don't have a burden of proof. And it goes on to explain that it's not unanimous. Any juror can be persuaded of the existence of mitigating circumstances. My question, though, would be, does the prosecution have to, do they have a burden to prove that mitigating circumstances do not exist? Is that what the argument is? Okay, let's continue. Florida's procedure follows the same rules, and thus it is similarly difficult to assign a standard of proof to the mitigating circumstances in Florida's statutory scheme. I wonder what mitigating circumstances, what are the mitigating circumstances that they are coming up with in their defense? Because remember, in the conversation that was recorded that he had with his parents, he said something like, I didn't start this. Okay, anyway, the standard instruction does not follow the law as set out in section 921.141 of the Florida statutes and is therefore an incorrect statement of law. The standard jury instruction 7.11 regarding the burden of proof for mitigating factors denies Mr. Sterns a fair trial and due process under the Florida Constitution and the 6th, 8th, and 14th Amendments to the United States Constitution. 6th Amendment is right to counsel, right? 6th Amendment. 6th Amendment protects the people, right to a speedy and public trial, right to know the charges, right to confront witnesses, right to legal representation. 8th Amendment is protection against cruel and unusual punishment, excessive bail, excessive fines. 14th Amendment is, the 14th Amendment was ratified in 1868 and extended the rights and liberties in the Bill of Rights to formerly enslaved people. It granted citizenship, equal protection, and due process. Okay, gotcha. All right, so let's continue. Wherefore, Mr. Sterns respectfully requests this honorable court enter an order removing from the jury instructions any language that places on the defense the burden of proving mitigating circumstances. I don't know. I think that's a compelling argument. I'm curious to see what the prosecution will say to it, what their answer will be. I haven't seen it yet. But the deeper question for me are, what can be the mitigating circumstances that reduce the culpability or the blame or the responsibility for this young lady to have suffered for at least 5 years repeated, aggravated SA at the hands of this man and under the nose of this woman? What are those mitigating circumstances? And then, what mitigating circumstances would reduce the blame of the murder of this young lady allegedly at the hands of this man and under the nose of this woman. What are they? I would love to know your comments. Let's go over to your comments. We'll bring Maddie up on the screen. Let me just, real quick, we go here. Trissa, I'm sorry. Wait a minute. Why isn't this showing up? Got to bring it up. Because it's green. For some reason, it doesn't do that. She says, your insights and delivery are amazing. Love you so much. Hope you have the most wonderful holiday. Thank you for everything. Oh my goodness. That was very kind. Thank you very much. I appreciate that. And I'm sorry that I butchered your handle. That is terrible of me. But thank you very much for the super chat. I deeply appreciate that. Let me go back to other Autumn Doyle. I'll be over to get some jugs of water. Yes, because Franklin water is horrible water. All right. Let's keep on. Misty Mo, Gavin, mitigating circumstance equals Jennifer Soto. I mean, that's the one that came to my mind, but I mean, what is it that you would argue that I have less blame from what I did because somebody else was doing it before me? I mean, I don't think you're wrong that that's probably one of the things that they're thinking of in their defense. I just don't know that it's going to hold water. Tony says, Gavin, I knew this was going to happen. He's going to tell on Jennifer Soto. Probably. Tammy thinks he's going to claim mental health issues. I mean, his mother has claimed that he has those kinds of issues. I don't want to put words into her mouth. I should say I think that she has said that, blaming the head trauma that he experienced as a young man. Jenna Lee asking, oh goodness, would Jen be a mitigating circumstance? You know what we need? We need a lawyer to talk about this. We need a lawyer. And I know that there are some lawyers in the crowd that are watching this because a couple of you have reached out to me, and yet so many of you said, but I don't want to go on camera and talk about it. I would love somebody who is a defense lawyer, for example, a criminal defense lawyer. Let's talk about this. I would love that. Let's see. Friend of Crows says, there are no mitigating circumstances, only aggravating circumstances for Stephan Sterns. It didn't work for Bobby Joe Long. It won't work for Sterns either. He's going to try to use his previous head injury as mitigating circumstances. Good comment. Very good comment. Thank you very much for that. Patty Ward, he will probably say she died from an accidental overdose. That is an interesting thought. That is an interesting thought, Patty. Because we have evidence in the form of some interviews. One interview that I can think of, which is the one with Jennifer Soto, where she is in the little interview room with the couch and everything, where she talks about, I think, 2 different times when they accidentally overdosed Maddie. The medical examiner, though, according to the reports, we have not seen the medical examiner's report. We've only seen police reports that refer to the medical examiner's report, says that she died by strangulation. However, Patty, you might not be wrong. I mean, that is the opinion of a medical examiner. It is possible that a toxicology report would show that she had dangerous levels of drugs in her body. We don't know this, but it's possible. So you could get expert witnesses disagreeing with one another. The prosecution having an expert witness who is the medical examiner or the pathologist that examined her, and the defense having some other toxicology, or some other kind of forensic expert saying, no, this was enough to kill her. She probably didn't die that way. Yeah, that's also a compelling, that would be a compelling argument, I think. I don't know if it'd be compelling. It would be interesting, though. And this is the part where, in a case like Maddie's, I have to pause and remember we are talking about a little girl who lost her life and who lost her innocence over the course of, not over the course of, lost her innocence and then had to live through 5 years of abuse, right? We have to remember that this is a victim that we're talking about. I'm talking to myself here. We have to remember that we have a victim here, a little girl, a 13-year-old girl. But at the same time, this sort of intellectual exercise is interesting to me, and the law is something that is interesting to me, and I like to I like the wrangling, and I like the argument. I like the whole process. But I need to remember we're talking about Madeline here, right? Great comment, Patty. Thank you very much for that. Let's see. Gavin says, Kathy, Stephan has his own evidence against his own self on his own phone. Yeah, he does have that. Zach in Florida, thank you very much for chiming in. In Florida, serious crimes are tried at the district level. Less serious crimes are tried at the county level. Similar to the MDJ and PA handles M3 and lower, while common pleas handles M2 and felonies. Yeah, it's just MDJ is called district here, and then common pleas court is handled on a county level. So that's interesting, that the different terminology, but it's effectively the same thing. There are lower courts and there are higher courts. Thanks, Zach. I appreciate that. Jana, well, to bring her into the conviction, let's see. Just like his dad implicating Jen knowing, I wish phone calls could be FOIA'd. Probably later they will. Yeah, this is going to be a case, guys, where documentary series are made about it. It will be one of those cases. First of all, well, hold on. I should say, if it goes to trial. I'm trying to think. Florida's Sunshine Law is one that as a layperson, I'm pretty familiar with. And so, no, it doesn't have to go to trial. So whether he pleads this out, or he goes to trial and is convicted or found not guilty, all of that evidence, once it is adjudicated, there are some little exceptions that are carved out here and there, but all that evidence will be obtainable through public records requests. It'll probably cost a lot of money. But those phone calls, a lot of that evidence, I would really love to see, just to see what a strong case the state has against him. And I think if I were him, and I'm so glad that I'm not, but if I were, I would probably take this all the way to trial. Because the only leverage that the state's attorney might have is taking DP off the table to get me to plead it out. But if they don't take that off the table, which I think with the attention that this case is getting, maybe there will be enough political pressure where they don't take that off the table, then if I were him, I would take it all the way to trial. There's no downside to that in that case. So I think this is going to be interesting all the way around. Let's see. A. Murphy. Gavin, from my own personal experience, oh my goodness, I'm very sorry to hear that, A. Murphy. My mom knew about it, but but didn't do a thing about it. Is Jennifer being investigated? She texts Stearns saying she can't risk it anymore. I do think that Jennifer Soto probably will face charges. I really do. I'm hopeful of it. Yeah. And I'm very sorry about that for you. Let's see. Royal Blue says Deb Stearns says Stephan Sterns Hospital doesn't have his record, so they can't prove traumatic brain injury. Interesting. For some reason, my highlighter isn't working like it normally does that highlights the GFs. Let me keep going here, you guys. Yeah, brain injury. Zach says, Gavin, I don't believe he has a mitigating circumstance. He drove around with Madeline's body and summarily dumped her in the bush. Yeah. Let's get Jen's picture off of there. Sorry, guys. I mean, they're going to have to make an argument that to a jury, and they're going to have to convince a jury, not all members, but some members, that mitigating circumstances exist. Traumatic brain injury, maybe he was abused as a child, maybe he could argue, I'm not saying this is true, but maybe he could argue that Jennifer Soto served up her daughter on a silver platter, that she had been abused by others, and it was something that she did for her boyfriends. Ew, that's just gross to think about. But there are things that they can make an argument. Whether or not the jury believes it will be a different thing. Be a very different thing. Yes, the injury as a child, but was never diagnosed. Yeah, the same thing. Princess Takalu. Great handles, guys. Horror Queen Gavin, surely with all the photographic evidence of the essay of Maddie, this monster can't possibly believe he can get away with it. Love your coverage of this story. You're the only one I watch on it. Well, thank you very much. Gavin, learning so much from you. I think they're going to bring up the medications. Rachel. I've never seen that spelling of the name. I hope that I'm pronouncing it correctly. But yes, Stephan Sterns was also on medications. He was also had prescription medications. Am I remembering that wrong? I think I'm remembering that right. It's not only the medications that Maddie was suffering, but maybe his own medications were causing him to act the way he did. Who knows? Lisa says, in my opinion, the head injury is fabricated. Let's see. Deb Stern mentioned in a call, says Royal Blue, that the hospital doesn't have his med records, so the defense can't prove DBI as a mitigating factor. I would discount what it is that she says, because medical records are typically forever. And I would imagine that records that are 20 years old, 25 years old, whatever they are probably paper records. They're probably not digital records even 20 years ago. They're probably paper records. The hospital probably has them on an offsite location, unless there are destruction protocols, which I can't remember. No, I think it's 14 years. I'm trying to remember HIPAA guidelines. Let me look that up real quick. I think you've got me on this one. How long does HIPAA require record retention? I think it's 6 years is what HIPAA requires. So maybe they don't have them. Maybe they don't. Great comment. Thank you very much. Amanda GC, Gavin, her neck was broken, so if he tries to say that she overdosed, he'll probably also say he was trying to save her life or something. I don't know that it said that her neck was broken. Amanda, I would love to know where that piece of information came from. I may have missed it. What I recall is that strangulation was the cause of death. But you know how you can send that to me? If you go to my website, gavinfish.com, bring you over here, there's always a link down below, and you click on this little icon right here, that will take you to a contact form. You can send me the information. I would love it. I get a lot of these, a lot. I go through and I read them. Sometimes it's a few days before I get to them. I go through and I read them. I don't respond to the vast majority of them. I'm sorry to say that I can't do that right now. But I do read them. So Amanda, if you have some information beyond what I recall, please send it my way. That goes for any of you. I would love that. And thank you. Let's get back to other comments. Thanks, Amanda. Thanks for that comment. Donna says broken hyoid. I don't know. I don't remember any of those details. I don't remember any of those details. Hey, wait a minute. Mooney, is it your 9-month anniversary? 9 months? Mooney's the OG, everybody. She's one of my intrepid moderators. She has been a supporter of mine since the beginning. Mooney, I'm going to talk to Mooney for a second, everybody. You can listen in, it's fine. Mooney, remember when you came up to Western PA for the in-person thing that we did in Clarion? I called it True Crime Convo. Remember that? Of course you do. Because you made the effort. You came here all the way from your home state, which is amazing. I was at a Christmas party of our neighbors on Saturday. And our neighbors were also there. I love our neighbors, by the way. They're amazing. So we were at the little neighborhood Christmas party that they hold at their house. So much fun. And he was like, when are you going to do another one of those in-person things? And he said it was so much fun. So I think I might do it again. I think I might do True Crime Convo number 2 in January or February. Probably February. I need some time to plan it out. I need to get a venue. But yeah, I think I'm going to do a True Crime Convo. A Crime Convo. Whatever. I can't remember what I called it. But that's what we're going to do. And thank you, Mooney is the best. Everybody, you all know she's the best too, right? We all know this. She's amazing. Irene, Gavin, Madeline Soto had a broken right eye bone. Stephan Sterns can't say overdose. Guys, I must have missed something because I'm hearing broken neck. I'm hearing broken hyoid. I'm hearing broken right eye bone. But I have missed all this, which, I mean, doesn't surprise me. It's easy to miss things like this in a case where so much information has come out. Please, please, please go to my website, go to the forum, and send me your source material. It could be an article. It could be another YouTube channel. It could be one of the documents that came out. I just don't remember any of that. But I would love to read it. I would love to read it. Yeah, and Irene says broken hyoid. I just don't remember that at all. Yeah, Irene, I see your comment. You don't need to do it multiple times. Gavin, here in Florida, Ron DeSantis's best contribution was to make SA on a child under 12 a capital offense. I hope this one is it. So I know that Florida has done that. I think it probably violates the 8th Amendment or the 6th Amendment, but we'll see. There has to be a case where somebody is tried for a capital offense for SA in the state of Florida in order for it to be challenged in court to go all the way up to the Supreme Court. So maybe this one will be it. I think it's a recognition at the very least of the seriousness of what that kind of assault is. I think it is the worst crime. I think it is the very worst crime that a human being can impose on another human being, I think it is worse than murder. And I think it's about time that jurisdictions across the fruited plain agree on that and decide to take it seriously. Because, I mean, look at the other case that we're looking at right now, where Sabrina Adkins in Kentucky, my fellow Appalachian brethren and sistren of Kentucky, Ben Fields was convicted of the R word and got 6 months in jail. So, of course, I mean, well, I'm not going to forgive it. It wasn't a child, but it still is what it is, and it's a horrible, horrible thing. So, yeah, I hope this. I wonder if it will hold up under the Supreme Court, and not to get political here, because the Supreme Court is supposed to be apolitical. But if there were ever a court that would uphold this kind of law, it would be the current court, the current Roberts Court. And I don't know if you guys, I don't know how much you guys pay attention. Each one of you pays attention to the Supreme Court. But I pay attention to it pretty frequently. It's a day. I go to a website called SCOTUS blog every single day. My day starts with perusing the daily news, perusing the true crime news, and reading what's going on in the Supreme Court on opinion days. I usually read opinions. SCOTUS blog is where it is at. And I do think that maybe that is something that the state's attorney will want to do here. Is make this a capital case on the SA part, which they are charging that. Keep it a capital case, and then see if they can get that to this court. We'll see what happens. Let's bring Maddie back up. L. Arnold, Gavin, I wonder if they always had to watch her when taking her meds because she might not take it. Then it would throw off the abuse they planned that night. Ooh, that's a scary thought. It's a scary, scary thought. I'll keep on going. Oh, sorry. Nifty 50. In my opinion, I think Stephan Sterns is getting Jennifer Soto involved too, especially since he said he didn't start this, and his parents asked why he didn't pull Jennifer Soto into the mix, and he said he never had the chance yet. Yeah. Okay, let me keep going. Did I see another? I did. Did I see another one? Another super chat? Thank you very much, Tabitha. I appreciate that. Appreciate that deeply. Mooney, thank you very much for gifting those memberships. Guys, you guys are amazing. Keep going down. Sorry, I've got a... Who just said that? 8th Amendment violation. Yeah, 8th Amendment violation. Thank you. Mooney, thanks for giving out those memberships. You are awesome. Hey, Autumn Doyle is an 8-month member. Autumn, our chief moderator. Autumn takes care of me, guys. And actually, you know what's funny is Autumn and I have never met in person, but we live in the same town. Hopefully we're going to fix that tomorrow, which is pretty cool. Gavin, we learned and spoke about it when you had your guest on all about strangulation. So, but I don't think, well, we talked about the telltale signs of strangulation, but I don't think that we've seen a document saying that the hyoid bone was broken. But I might be totally wrong, guys. I'm sorry if I am. Sorry if I am. Goodness, it keeps refreshing on me. I'm just going to do a couple more here. Serenity Gateway says, Gavin, I suspect Stephan will say that everything with Maddie was consensual and they were in a relationship. Still illegal, but perhaps will be part of his story to speak to his mental state of mind. Yeah, that maybe he will. It's gross to think about, but I mean, we obviously you already said this that like obviously it wasn't consensual. She was a child, 8, 9, 10, 11, 12, 13 years old. That goes without saying, but I mean, whew. Taylor, this is your first live? Well, welcome, Taylor. Glad you're here. Couple more before we call it a night. Lauren says, Gavin, I'm hoping that Stephan Sterns is man enough to give up Jennifer Soto if she's involved, but to sink with him, not to get himself a cushy deal. Yeah, I agree. And Mary says, ask Grizzly. Okay, I will ask. Guys, that is going to do it for tonight. It's a little bit shorter than normal, but I'm so glad that you all were here. A couple things before we go. Don't forget about the fish tank. If you're on Facebook, head on over to the fish tank. The best way to find the fish tank, well, if you're on Facebook, you can just search fish tank. But if you're on my website and you click this little fishy right here, it'll open up the fish tank where we have like 3,200 people that have joined in on the conversation. Oh my goodness, somebody won a fancy pin tonight. Yay, a 100K pin. Congratulations, Tammy. But we've got lots of things going on over here in the fish tank. So if that is your deal, I invite you to go ahead and join us. Don't forget about Crime Cod. On the front page of my website, I publish daily several articles about things that are happening in the true crime sphere. When you click on those articles, that will take you over to Crime Cod, which is my true crime website. I'm so grateful to Jake Deemer for keeping the website up to date, writing articles for you guys to read. If you join the newsletter, which you can do by clicking right over here, I will occasionally send out true crime news. So I invite you to join the newsletter. Bring that up, crimecod.com. See what I did there? I'm really leaning into this fish thing, guys. Hey, with that, I think that is enough for tonight. Thank you so much for joining me, everybody on the live, everybody on the replay crew. I hope you have a terrific weekend. For this video tonight, we had to push a couple videos back, but we will be back on Monday to continue, hopefully, our conversation about the Judge Mullins murder. And when we do that, I hope that you join me. And then I'm going to be winging my way with my family all the way back to California, the land from which I come, to visit my folks, Kimberly's folks, all the in-laws and the little cousins and nieces and nephews and everything. I'm really looking forward to it. I've got maybe the most adorable nieces and nephews on the planet. So I'm really looking forward to that. So through the Christmas break, I will not be doing live streams. I'll be spending that time with my family, but I am preparing one like pre-produced video that will be coming out sometime during there. So keep your eye open for that. Okay. With that, I am a Tchaikovsky symphony. I've tried to close this out so many times. Thanks for joining me. I'll see you tomorrow. Take care. Thank you very much for watching this video. If you liked what you saw, please consider subscribing. And if you have any questions or comments, please leave them below.